everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So today we have one article that is an editorial for our discussion. The title of this editorial is Strengthen Secularism, Save the Republic, which has been taken from the Hindu newspaper. And as the name itself is suggesting, this talks about the secularism as a character of the Indian system, and specifically keeping at mind and in our discussions, the hijab judgment that has come up at the Karnataka High Court. So how is it going to attack on the secular character and the secular fabric of the society, and how we should be saving the republic will be discussed here. Secondly, we have the news update segment for our prelims exam, and we'll be concluding with the legal news in the end. So let's start with the discussion of the article for the day, which talks about strengthening the secularism and saving the republic. So the Karnataka High Court's order on the hijab issue has only furthered the anger of Muslim students in Udupi, leading to the other being challenged in the Supreme Court. So as we know, that Karnataka High Court has said that wearing hijab will not form a part of the essential religious practices under Article 25 of the Indian Constitution. And this has actually raged out a lot of Muslim students in Udupi. And this has actually led to taking up of this decision being challenged in the Supreme Court. So the ruling of the Karnataka seems very technical, where an issue of violation of fundamental rights was adjudged merely on the issue of proper pleading. Let's see, India has always had the eagerness to welcome people with open arms, and this moral framework was adopted by the Indian Constitution as well when we were discussing about having a secular state. Also, it must be noted that the term secular was specifically added through 42nd Constitutional Amendment Act of 1976, wherein the term secular was added to the Indian preamble. So this is greatly reflected in how India promises religious freedom on one hand and secularism for the government to enact on the other. Now, as we know that we have fundamental rights ranging from Articles 25 to 28, wherein we are guaranteed secularism, and also the state says that the government says that it will not have a religion of its own. However, secularism is different in India from that is observed in European countries. In India, the state has no religion of its own, and hence no tax can be levied on a particular religion. According to Article 27, the state cannot spend money for the promotion of a particular religion or promote a religion in the educational institutions funded by the states wholly, which is Article 28. Also, Article 15 prohibits any kind of discrimination on religion, and Article 25, Clause 2, Subclause A allows state to regulate secular activities. However, India's religiosity would inevitably lead to a theocratic state. Basically, a theocratic state would be like, for example, Pakistan, that has a religion, a state religion, as in even they have taken up Islam for that purpose. So the largest minority is 200 million, rendering such position inoperable. So in India, that would definitely not be a good case of declaring it as a theocratic state. Further, the minority religion runs on a particular hierarchy and class structure. Now here what we are trying to say is that if in the worst case scenario, we were to turn India into a theocratic state, that would not be a feasible and possible question for us, because firstly, we are to consider the minority religion. So even the largest minority religion is 200 million, which is huge. And definitely if we talk about the majority religion, that is Hinduism in India, it is further distorted, it is further, suffering with a lot of hierarchical and class structure issues. And that is why it will point an endless conflict and operation of the subaltern people, leading to disintegration of the society. And therefore, it is evident that India would not survive in such a state, and it is imperative that the secularism is upheld. So the religio-political campaigns have been troubling the multi-religious and multicultural character of the country, and that is why we should be more tolerant and accommodative if at all we are really trying to become, or if we really want to become a secular country, not just in letter, but also in spirit. Let's see what do we have for the news updates today. Parliament passes bill to merge 3 municipal corporations in Delhi. So the Rajya Sabha on Tuesday passed the Delhi Municipal Corporation Amendment Bill 2022, which seeks to merge 3 municipal corporations in the national capital. It was passed by the Lok Sabha on March 30th. The bill introduced by Home Minister Amit Shah seeks to amend the Delhi Municipal Corporation Act 1957 and unify South Delhi Municipal Corporation, North Delhi Municipal Corporation, and East Delhi Municipal Corporation into the Municipal Corporation of Delhi. Then we have the broadcast Seva portal. So the Ministry of Information and Broadcasting on Monday launched the broadcast Seva portal, an online portal aimed at providing at improving ease of doing business in the broadcast industry. So this will be an online portal solution for speedy filing and processing of applications of broadcasters for various kinds of licenses, permissions, registrations, and so on. Then we have the 6th anniversary of Stand Up India. So Stand Up India was launched by Government of India on 5th April 2016 to support entrepreneurship among women and SC and ST communities. Over 30,160 crore rupees sanctioned under Stand Up India scheme to more than 1,33,995 accounts since inception of the scheme. Then we have the legal news. The Supreme Court seeks centre's response to plea challenging Section 15 of Hindu Succession Act as discriminatory against women. The Supreme Court on Wednesday sought centre's response in the plea challenging the constitutional validity of Section 15 of the Hindu Succession Act on the ground of gender discrimination. The petitioner challenges the provision arguing that there is discrimination in the devolution in case of a woman dying intestate in comparison with the rules for devolution where a male has died intestate. By intestate, we mean someone who has died without having a will. The name of the case here is Kamal Anand Khopkar versus Union of India and others. So this was all for today. We hope it was a good session for you all. Thank you so much for staying tuned with LawSikho. If you wish to download the PDF of today's slides, you can download them through our Telegram channel. The link is there in the description box below, or you can scan this QR code that you can see on your screens right now. Also, for other content, please do not forget to follow us on our official Instagram channels for LawSikho Judiciary, CLAT Prep, UGC Net, Law Finance Exams, and thank you so much.